My name is Professor Olalekan Akimbo. I work for African Union Development Agency, NEPAD. I'm the head of the Innovation Hub for Science, Technology, and Innovation Center. So it's nice having all of you here. I want my co-moderator to introduce herself, then we move on to gain time. Georgiana?
All right, I'm just trying to make sure that you can hear me. Give me a sign if yes. All right, excellent. Thank you very much. Well, good morning, everybody. It's really a pleasure to be with you here today. My name is Georgiana Makovei, and I'm here to co-moderate the session with the distinguished Professor Akimbo in my capacity as Policy Officer and Program Manager for Digital Entrepreneurship, Innovation and Investment at the EU, more specifically at the Directorate General for International Partnerships. That was a mouthful. So it's a pleasure to be here with you today. Over to you, Professor Akimbo.
Thank you so much. Just for me to quickly introduce the session, we are going to the session that is Deep Technology Training Transformation Scheme, the IP Strategic for Innovation. And we'll be looking at we start with the basics, giving an overview of what is important for the intellectual property right in the innovation ecosystem. Then also we have a little bit of explanation for the different type of IPR in the case of patency and copyright, the trademark, trade secrets, and their relevance. I think I turn this over to Georgia, which will introduce the key speaker that will also take us through from his wealth of experience. Georgiana, please, over to you.
Absolutely. Thank you very much, Professor Akimbo. Perhaps just to complement that, as Professor Akimbo already explained, for the next 90 minutes, we will really immerse ourselves in the topic of intellectual property rights, and we will hear from experts from both Europe and Africa. Just to explain the rules, so we have two distinct presentation blocks, and after each presentation block, we will have Q&A session. So we will open the floor for questions where you will have the opportunity to ask your most burning question to the presenters. So since time is short, I would like to dive right into our first presentation, which will take us back to basics, highlighting the importance of intellectual property in innovation ecosystems, and also very importantly, giving practical tips on how to navigate the patent process. And bringing us this topic today, we have the honor of welcoming Professor Alfred Radawa to the workshop. Professor Radawa heads the Institute of Business Administration and Management at the IMC University of Applied Sciences in Krems, Austria. And aside managing the different bachelor and master's program at the university, Professor Radawa also focuses on research on innovation policy and its intersection with adjacent policy areas such as intellectual property, which is the topic for today. So without further ado, Professor Radawa, over to you.
It's an honor to be invited and to be able to speak here. So, as I have been already introduced in person, I will start straight ahead with the presentation. So, intellectual property rights, what are we talking about here in the case of innovation? Yeah, and if we talk intellectual property rights, the first thing that comes to mind when is the name patents. Yeah. And it is true, patents are indeed a type of intellectual property rights, but the very, very first recognition that has to be made is that intellectual property is more than just patents. Yeah, we have a diversity of instruments and tools. I'll call them specifically instruments and tools, as you will see later, for a specific purpose. It is important to understand that intellectual property is not just patents, and it's much more. Yeah, we have really a number of tools and instruments available, which differ in terms of what they are doing in order to foster innovation. And here's the first thing. The intellectual property system, and here particularly also the patents, have been invented, so to speak, decades, centuries ago, yeah, with a specific aim of fostering innovation. Yeah? And over time, this fact seems to have been forgotten, because when you see people talking about intellectual property, it is usually done from a legal perspective by lawyers, yeah, And when you see people talking about innovation support and innovation policy, it is done usually by economists who are innovation policy. And somehow the connection between intellectual property on one hand and innovation on the other hand, over the centuries has been severed to an extent. And so one of the important things to understand is that intellectual property rights are there to foster innovation, most of them, yeah? And as I said, patents are just one type of intellectual property rights, and there are many more which differ not only by name, but also what they are protecting and how they are protecting it. And also what's not here on the graph, which I've taken from a teaching slide deck from the European Patent Office, in terms of duration of the protection. Yeah. So let's start first with the patents here in the first line. And there is a reason why you have patents in the first line highlighted. And the reason is that you can sort the instruments of the system of intellectual property rights by their degree of legal formality. Yeah. So there are instruments that are formally very strict, very legal, and there are instruments that are not legally as defined and are more to be seen as management practices. Then we are talking about informal protection mechanisms. But the most formal intellectual property right is indeed the patent. Yeah? The patent protects new inventions, that is a solution to a technological problem. Yeah, the way you are solving a technological problem, which is why you will see here this specific type of drawing, which you find in many patent specifications, which show how a specific problem is being solved. How is a patent protecting the respective innovation? It's been done through application and examination. Yeah, so people who want to have a patent usually have to apply for a patent at a patent office in the respective countries. The patent application is then examined and it's then granted if it fulfills certain criteria. Yeah, the criteria are 3 to 4 of them. The 3 criteria are that it has to be something new, it has to be something in addition inventive, so something not obvious to the expert in the field. Yeah, it has to be capable of commercial application, and it has to be specifically not on a list that are by definition not patentable. So no need to memorize all these things by heart, but the thing is there are certain standards to be met so that a new invention can be really claimed as new and inventive. Yeah? You have in the second line the so-called utility models, which are sort of a patent light. Yeah, usually in some jurisdictions available, in others not. And the major difference between a patent and the utility model is that the standards applied to utility model are lower, what you require for the protection to kick in. Usually, you will not have an examination taking place, but just a registration. And so it is left to courts to decide whether the right is really rightfully being given to people. And at the same time, also the scope of protection is reduced. For example, the maximum duration of a utility model is usually set at 10 years, while a patent by international contracts will last for up to 20 years. Yeah. So how are patents and also utility models incentivizing innovation? Yeah. The thing is that if you have an invention, typically an inventor will not want to disclose how the invention works because there has been effort put into creating the invention, because there have been investments made. And if you publish your research results and the way the invention works, all other people can copy it, and you will not be able to reap the benefits from the expenses that you have had. So the idea that was then born already in ancient Greece and that was then modernized then in Venice in the 15th, 16th century was, let's make a deal. Let's make a deal between society and an inventor. And the deal goes as follows, and it's called a social contract. If, dear inventor, you tell us the secret behind your patent, yeah, you publish it, we will give you some sort of protection, some exclusion rights. So only you, for a limited amount of time, will be able to commercially exploit it. Yeah, and that's a very, very crucial point to understand how the patent system works. The patent system actually means that people publish the secrets behind their invention. Yeah, it's a publication, it's a specific type of publication. So things like follow-up innovations can take place. So things like if the inventor dies, then the invention doesn't die with him or her, that this situation doesn't ensure, and that the secret is basically revealed to the public. Yeah, the protection window is then set to maximum of 20 years, after which the invention will be in the public domain. Yeah. So that's the mechanism behind it, and that's the mechanism specific to patents. And we have a little bit different other mechanisms if we look to other types of intellectual property rights that work also differently. So one of the things that you have to memorize is that you should not mix up the different IP instruments. Yeah, let's consider now another IP instrument, which is the copyright. Yeah, the copyright is provided for original, creative, or artistic forms that are fixed onto a medium. Yeah, how does the protection work? Well, in contrast to patents, there is no application and examination process. It just exists automatically. How? At the moment, the respective works is being saved on a file, in written form, in a document. That very moment, you created a copyright. Yeah, and the thing is that it's the specific expression that's being protected. So let's think, for example, about some person writing a novel. Let's say it's a novel where there is a secret hidden in the Mona Lisa painting in Paris, and people find out that there is the secret is a code that reveals some other secrets, and there is some kind of action then taking place. Now, this is a story, and the story as such is not protected by the copyright, but the respective way it is written by the author of the novel who tells the story. So the same story told differently will create a new copyright, and it's only if people copy the text one-to-one that you will have a respective copyright infringement. Yeah. How does this differ, for example, to the patent? Apart from the fact that it's something completely different in terms of what it protects, yeah, as you can see, the patent protects how things are done to solve a problem, while the copyright doesn't basically have the same kind of mechanism, but is focused on the actual expression of the idea and not on the way the things work. This is important when you think, for example, about software, because copyright is considered like a piece of art. Yeah, so it is protected by software is protected by copyright, which means that it's the original expression, the way the code has been written, that's protected, but not the algorithm behind it. Yeah? So these are two major tools, patents, copyrights. Now there are also other tools that need to be considered. And the next tool that you need to consider, and which is very important, is the trademarks. Yeah. And if you see a sign like Google, yeah, or you see a Mercedes, a Daimler star, yeah, you as a consumer will immediately think of a certain type of product and of a certain type of company. Yeah. So if you see Google, you immediately think of the search engine and the company Google, respectively Alphabet, that's behind Google. And this specific function to create associations, this distinctiveness that a sign creates, that's the one thing that's protected by a trademark. How do you get it? You have to use it, otherwise if you register it, you will actually even lose it, and you have to register it for it to have really full respective protection. The next legal right is the registered design, which protects the outward appearance of products. So let's see, for example, this Coca-Cola bottle, and you can see that this bottle has a very specific form, yeah? And it's not necessary for this form to create any kind of associations with you, linking it to Coca-Cola, but the form itself is protectable by something called a registered design. It's the external appearance of a product. And it's very important, again, to understand that these registered designs are again something completely different as opposed to patents. Yeah, let's look back. Patents protect new inventions, the way a technology works. Yeah, and the registered designs protects the external appearance. Where does this come into play? For example, if you think about how a smartphone looks like, yeah, and you think a smartphone, how does it look like? It's a rectangular piece of equipment, rather slim. It has a big screen on the front, one button or even no button on the screen. Yeah, this is basically the way a smartphone looks like. Yeah, it's something that's technologically given. Yeah, and something that's technologically given in terms of external appearance is not protectable by a registered design. Yeah, because the technology requires a smartphone to look like it does. However, what you can protect is the respective edges of the smartphone, because edges can be round, edges can have some sort of corner, yeah, they can have some ornamentation, like a frame for a picture, for example. Yeah, this is not technologically given, and hence it is susceptible to design protection. You can protect it. And then people start to mix things up. So if you look back, Google a little bit into the history, you will find a lot of journalists talking about the patent system being broken because there has been a dispute between Apple and Samsung on the rounded edges of the iPhone. Yeah? And the thing was to say, well, you can now even patent rounded edges. How broken can the patent system be? And the answer is no, journalists, you got it wrong. Yeah, it's not that the rounded edges are a patent in the sense of a technological solution. They are protected as a design, yeah, a registered design. And if you think that a designer has a right to protect his respective output, then you will have also external appearances protectable by registered designs. Yeah. And so we are talking about two different things, and people are mixing it incredibly up. Last but not least, I want to talk about trade secrets as another type of intellectual property. Actually, it's a borderline case, whether it's really an intellectual property right or already an informal protection mechanism. But basically, keeping things secret, yeah, is also a way of protecting property or assets, intellectual assets. Yeah. And what very few people know is that by international law, if certain criteria are met, then you will also get legal protection for keeping things secret. Yeah. The thing is, in order to qualify as a trade secret, the information must be, of course, secret, so not known to the general public. Yeah. It must have commercial value, meaning it must have commercial value arising from the secrecy. I'm not going into the detail what this specifically means, but it has to have commercial value. And the third thing, you have to have adequate measures in place so to keep the secret secret. If these three preconditions are met, you will have a trade secret which provides protection against at least things like industrial espionage. So if people unlawfully acquire the trade secret. Yeah. So these are the major instruments. And if we talk about products as you can see them today, and I'm again taking a smartphone, you will see that several products that you will buy today have all of the IP incorporated into them. Yeah, let's take a smartphone. You will have a lot of technology behind it. Yeah, enormous amounts of patents that do things like how the screen's working, how the Wi-Fi is working, the navigation chip inside. So everything in that is protected by patents. Then you have the operating system, the manuals, which are protected by copyrights. You have the design. Yeah, as I said, the overall form of a smartphone is given by technology, but things like the rounded edges or these buttons, yeah, they are of artistic nature and they can be protected by designs. There are trademarks on them like Nokia, Apple, etc. The product configuration, even startup tones can be protected by that. And there may be also trade secrets behind a product where certain things of the product are not being disclosed. Yeah. So this example alone gives you already an indication of how important intellectual property is to commercialize research results, to get innovations into place and be able to reap commercially the benefits from it. Now, the thing is, what you will see, and here I'm quoting a study from a German journal who looked at innovative German manufacturing firms. Firms are using all these instruments in parallel, yeah? In all kinds of products. You will see that patents are being used. You will see that utility models are being used. It's a little bit worrying that industrial designs are not that used, but they are also used. But you will also see that these informal protection mechanisms, secrecy, relying on lead time advantages and so on, they are also used. They are actually even more used than the formal IP rights. And you see, because all these things don't add up to 100%, that they are instruments that are working in parallel, they are working in complementary sets, and the question is, how are they working together? And I'm going to come back to that just shortly. Short excursion, how do you get your intellectual property rights? Well, as you can see, the differences, there are differences according to IP right. Some of them arise automatically. Some of them will go through an application procedure. The most thorough application and examination procedure is taking place with a patent, but the process is always the same. You have an application, you need to draft a patent application, you have to submit it to a patent office, it's going to be examined, and after examination, it's being granted. Yeah? The thing is, this is the very simple overview, but you will see that in order to get a patent, you will have, particularly at international level, different paths available, and all of these paths are available in parallel. Yeah? You can file your patent at your national patent offices and at other national patent offices. You can have international harmonized application procedures, which means you apply at the patent office in Europe, like the European Patent Office, which is one office which examines the patent against the patentability criteria and then issues national patents. Or, as we can see just very shortly, there is even such a thing as international patents, because this year you will also have seen the introduction of the unitary patent in Europe, which is one patent covering several nations. Yeah, but the general process is that you have a patent for each country. That's the general thing that's called the territoriality principle. And this is also very important to remember, because that means that if you have a patent, for example, filed for in Kenya, you will not have patent protection in Germany or in the US. You will have to file patent applications separately for Germany and for the US to enjoy protection in these three countries too. This is important when you think about commercializing your inventions. You need to go where your markets are and where your competitors are and have protection there. What you cannot do in practical terms is you cannot protect your patent in every country of the world, because that's extremely expensive. Each country charges its own application fees, processing fees, renewal fees for patents. And if you try to patent an invention in every country, it will be prohibitively expensive. Yeah, so you will have to focus on those countries where you have patents, where you have markets, and that's the ones where you go for, and then you can use one of these procedures where you get the patent. That you need to get a patent, you can see by this graph, which shows you that company values today are more and more determined by the intellectual assets. Yeah, so like in the 70s, the company values of leading companies have been determined mostly by physical assets such as infrastructure, buildings, machines, and so on. Today, the company value is mostly determined through the intellectual assets like patents and so on. Yeah. So this was like a very, very brief and really in a nutshell and fast introduction to the system of intellectual property rights, which basically says, and that's important to remember, there is more than just patents. This instrument differs by what they protect and how they protect it, in particular the application procedures, and that these application procedures are also differently strict in terms of legal strictness, yeah, with the patenting process being the most formal one. Yeah. So what does this mean now? Yeah. And one thing, and there's one very, very important takeaway that I want you to take from this introductory presentation. It doesn't mean that you have to run for each and every intellectual property right that you see. Yeah. And I can give you one example. And the famous example to illustrate it is Coca-Cola. You know, I think everybody knows the beverage, and everybody knows, or I think it's known, that the recipe behind the original beverage is secret. And there is a reason behind that. If Coca-Cola would have, and I am assuming that it's patentable, which is a question itself, but let's think about that the recipe would have been patentable, yeah, and they would have filed for a patent. What Coca-Cola would have basically done is they would have published the recipe to the whole of the world. And in those countries where they will not have patent protection, everybody would be legally free to create a Coca-Cola drink with the original recipe. And after 20 years, everybody in the world would have been free to create Coca-Cola with the original recipe. Yeah. And obviously, that's not a good basis for the business model of Coca-Cola. Yeah. So they used a different strategy. They said, let's protect the recipe as a trade secret, so it's not known to the general public, and add to it strong trademark protections and even marketing the secret as part of the marketing strategy. Yeah. And this has proven over the course of a decade to be a very, very over a century, to be a very, very successful IP strategy. What you can see is that there are cases where you want to have a patent, and that there are cases, situations where you do not want to have a patent. Yeah. So the first thing you need to do is to think, do I really want a patent? Yeah. And in some cases, the answer is yes. And in some cases, the answer is no. Yeah. And in some cases, I will use, instead of the patent, a different instrument for the intellectual property system, for the intellectual property protection. Yeah. And what does this actually mean? This means that you have to think of the system of intellectual property rights as a toolbox. Yeah. The patent can be maybe the hammer. Yeah. The trademark is the screwdriver. The trade secrets are another type of tool. Yeah. So it's all in a toolbox. Yeah. And the thing now is, it's about the mastery of the toolbox, as with a good craftsman. Yeah. You know the big joke that's being created. Yeah. There is some kind of person calling for a plumber. Yeah. And he gets home and he takes out a hammer and hammers one time on a boiler, and then it runs again, and then he creates an invoice for $1,000 for, and the customer doesn't want to pay it because he says $1,000 is way overpriced for just hitting one time with a hammer the boiler. Then the craftsman changes the invoice and says, okay, hammering with a hammer 1 cent, knowing where and how to hammer $999.99 US. Yeah, that's the picture you need to take from the intellectual property system. It's about the management and the mastery of the tools and be able to understand when to use a hammer and when not to use a hammer, when to use the screwdriver and when not to use the screwdriver. What you do not want to have is this picture here, where you try to hit your targets by even taking more patents, more trademarks, more utility models. If you do not do it in a clever way, you are not only wasting money, you are probably even endangering your business. Because consider the Coca-Cola example again. If you patent your Coca-Cola because somebody tells you patents are great, yeah, then you're basically ruining your business. However, if you have a great technological solution in a product, for example, which is easily to be disassembled, you may want to have a patent. Yeah. So all it is here is about IP management and having the right choices in the right context. What does this mean for policymakers and for businesses alike? You need skills, and these skills have to be basically at 3 levels. You have to have some sort of legal skills, that's clear, so that it is a legal topic, but you also have to view the IP toolbox from a business perspective. You have to ask yourselves, how can you use the tool to basically create value and create your business model? Yeah. Then there are also technical skills. For example, patents, you also need to have technical knowledge, but you have to have a combination of these 3 things, and you have to apply them in a business industry specific context to build your business models. Yeah. And that's what I find in the studies, I have witnessed many times, is a considerable barrier, because most of the people have a very naive view on IP in the beginning, where they basically have this the more the better view. Yeah, the more patents the better, the more copyright protection the better, and they forget about this clever usage and being able to understand when and how and why to use it. Yeah. Why is that? Yeah, because there is typically, and it's true for all countries and it's true for African countries, but it's also true for Austria, maybe at a different level, but you always have lack of awareness and knowledge on IP as the top barrier. Yeah. And it's about management skills. Yeah. It's not about that they know what a patent is and what a trademark is. That's knowledge they also often don't have. But it's about what a patent can do, what a patent cannot do, what a trademark can do, and what it cannot do. That's the missing thing, and this mastery of toolboxes from a business perspective. Yeah. You also have cost barriers. That's for clear, particularly when you talk about patents. As I said, patenting internationally can be prohibitively expensive. So you have to think about clever ways of patenting. You may want to pool your resources in your most promising inventions and support them only in your most promising countries. Yeah. And still be able to have some money back to enforce the IP rights. Yeah. So to be able to manage the cost. So there is also cost management aspect here behind it. A third aspect, which is related to the first one, is also some kind of I don't like IP. Yeah, it's such a boring, dry topic. Well, it is not. Yeah, it's actually a very, very lively topic. You have a lot of dynamics going on there, and it's not esoteric, and people can master it at every level to be really useful for business. And it's not too cumbersome and time consuming, because as you have seen from the Coca-Cola example, and let's not talk Coca-Cola, let's talk anything in the agricultural sector, in fashion, everything where you have processes at place and so on. Yeah, it's an investment. It's an investment into money making, into the business model. So you have to have the time to think about it, because you can either leverage your business, or if you take the wrong decision, you can even destroy your business. But there is a very high chance that one IP instrument is going to be relevant in any case for any type of industry, and particularly for technology-driven ones, you will have patents. For the creative ones, you will have copyrights, but you have to think about this IP rights in the way you create your strategy. IP is more than patents, and you should think about this toolbox and include also the informal means. Yeah, you have to be beware of thinking about IP too simple in forms of success metrics. So don't just measure your success as a country, as a company by the number of patents files. You need to focus more on IP management skills, and you need to take an interdisciplinary angle at the IP topic, combining legal, technological, and business views. So, and that's been from my side. Thank you very much. It was very fast, I understand, but I think it was also a little bit of a challenge to provide a meaningful introduction into everything with IP in just 35 minutes. Thank you very much, and I'm open for questions.
All right, thank you very much, Professor Rado. It was indeed a marathon, and really well done for taking us through it. I would just like to check if there are any questions from the floor.
We have one question.
Yes.
Or maybe it might not be a question, but I think let me just read it out. It said the role of IP for economic development is crucial, and as you mentioned, all tools need to be adapted to national context. A question on utility model. Germany and Japan applied the system in the past to protect incremental innovations. Will it be an opportunity to develop these two in Africa? And if so, is it possible to have the utility model system only in a certain domain? Example, the ICT. So to foster small businesses in that particular industry. That is the question for you, Alfred.
Yes, many thanks for this question. It is a very important question, actually. Yeah, and indeed, Japan and Germany, and particularly Japan, have used the tool to incentivize incremental innovations. And as such, it can be very, very useful, yeah, to get people acquainted to the topic of intellectual property, so they can see that they can also invent and get protection, at least at the local level, because utility models are usually very jurisdiction specific, very country specific. There are also countries that do not have them at all, like the US. Yeah, but if you have if people are discouraged from innovation because they think it's too expensive, because they think the advancements they are making over the state of the art is not good enough, yeah, because they think they do not have enough experience in dealing with intellectual property, then the utility model can really be a tool that can be advertised and used by local inventors to advance. Yeah, the question then becomes the next step, because the times are also a little bit different compared to when Japan has used them in the past. Yeah, and now we have much more dense networks of international contracts. Yeah, because a utility model is unexamined. Yeah, so you basically write and it's then checked only for formal aspects. Yeah, it's very, very difficult then, probably, if you do not have proper patent agent support, to create a patent out of it by, for example, using it as a priority filing, yeah, without going into detail. Yeah, so when you go international and you target international markets in the EU or in the US, you will probably have to consider normal patents and really good patent support so that you can be successful there. And again, from a national perspective, yeah, I have been in many countries which created national IP strategies, and one of the things that they did was they counted the number of patents filed. And usually many countries in the catching up economies, in the developing phases, have low numbers of patents, and they worry about them. Do not worry about that. Yeah, it's basically a reflection of the state of the economy. It's not that the patents lead the economy, the patents follow the economical development path. Yeah, so starting out with utility models to get acquainted, to get innovation started, is a good thing. But when it comes to patenting, in this context, I believe it's better to focus the country strategy and even the corporate strategies within the countries on the very few inventions there are that are truly of value and internationally exploitable and put all the money there, rather than create numerous patent applications of little value, which cost a lot, which make you look better in statistics like the Global Innovation Index, but in the end do not do a good benefit to the country. Yeah, you have to water it slowly and then water the plant so that it grows, and be very careful not to waste money. That's the point. I hope this
Thank you so
Thank
much.
you.
Yeah, just one more.
Sorry, can I? Thank you. Thank you very much, Professor Radau. I'd like to maybe stay on this topic if possible, and just to, I mean, you addressed also patents and utility models in your presentation. I think we understand the differences, but how can and how should inventors concretely choose which to go for, and according to which criteria? If I may ask you just to go a bit in depth on that particular topic, but very briefly, because we only have a few minutes left. Thank you.
If you have a small incremental advancement over the existing state of the art, and if your market is practically only local or mostly local, yeah, then the utility model can be a good instrument for you. Yeah, the utility model has also the advantage that it will prevent others, once you have published it, from patenting in other countries, which might be also an important aspect. If you have a very significant technological invention, which you can make a lot of money internationally, if it's not about a product process like a way of producing things like Coca-Cola recipe, but a product that can be disassembled, yeah, I would go for a patent. It's a very, very rough rule of the thumb kind of thing, and of a patent with patent applications also abroad, outside of the country.
All right, that was
Okay,
very
thank you
clear
so
for me.
much.
So, can I just ask maybe one question before we we move on? I think it's quite important because also Professor Radau mentioned a couple of practical tips, and I think it would be relevant for the audience maybe to hear about how a company can decide what features or products should be protected, and when. At which stage of the product development should they actually start about thinking about the process?
You should start about very, very early on, yeah, because the point is that if you do not start early on, you're doing mistakes. Like, you are so proud of your invention that you are presenting it at a conference, and when it's out in the wild and people have seen it, then it will not be patentable anymore because it's not new anymore. Yeah, so it's very important to think about the IP very early on, and it's also important to think about the IP and the innovation in terms of business model, because one thing is the innovation that you make, but it's also how you make money with it. Yeah, the business model behind it. So innovation, business model, and IP have to be thought of very early in the process together.